Good afternoon, good evening, everybody. Thank you very much for joining us in this webinar on, I think, very important topic about the rule of law. In the time of coronavirus crisis, but not only, we are not going only to speak about direct impact on the coronavirus crisis on the rule of law, but we are talking about situation which we experience now in various countries. And of course, it is also about the webinar about the abuse of the rule of law and the questions, what we can do about it. And I think it will be a subject matter of this discussion. Just before we are starting, and I would like to show our principles. Maybe we can start with showing the preamble of our paper. I would like to present very briefly our distinguished speakers. So we have a member of the Conseil d'État, Professor Bénédicte Fauvac-Cosson. From France, we have Lord Mans, the former Vice President of the Supreme Court of United Kingdom. We have Professor Leah Wortham from the Catholic University of America. We have Professor Andreas Stöckli from University of Freiburg. And we have Dr. Ziółkowski from the University, Koźmiński University from Warsaw. But now we are trying to look at our principles very briefly. But before I'm doing this, I would like to tell very briefly a story which I have experienced 2 weeks ago, exactly linking us to our topic. I was 2 weeks ago in Katowice. This is the capital of the region of Poland of Silesia. And when was the procedure against one of the Polish judges, disciplinary procedure against Judge Żurek, who has about, I don't know how many such procedures, 10 or more. And the reason is he is one of the leader of the Justitia, which is one of the Polish judges organization who try to oppose the decrease or demolition or annihilation of the independence of judiciary in Poland. And of course, the procedure, the problem was due to the COVID-19 situation, people were let outside. So usually in all these procedures against Judge Żurek, there are plenty of people who are coming into the courtroom and looking on this procedure and trying to somehow to observe that the rules of law and rule of law and due process is observed actually. And this time it was not possible. So people were waiting outside. But fortunately, the court has decided that because these people are not allowed to come in, this procedure must be stopped at this moment and postponed to the time when it will be possible. We can see here somehow the tension, this operation of the COVID-19 crisis somehow, which is impacting the procedure. But of course, the roots of this procedure, the roots of this situation are deeper and are not really connected to the, to the COVID-19, but of course they are impacted by the COVID-19. Okay, let's go with our principles. Can we put the second slide? We have here very shortly, as you know, the European Law Institute has adopted a number of principles related also to the question of the rule of law. The main aim of these principles is somehow to provide a guidance for the European states, but maybe not only European states, just to observe the rule of law, even in such situation of emergency. And of course, there are a lot of threats to the rule of law, because there is sometimes so that the rulers are trying to abuse the emergency situation to confine the rights and to use this COVID-19 situation to take over and monopolize and centralize their power. And this is exactly what we are talking in our framework, which we are trying to set limits, which are for the executive to gather the power and to use how to behave in this time, and how to observe the rule of law and not to use the opportunity to confine the fundamental rights of people. Maybe the next slide. Yes, this is our core provision, which probably has relevance to our discussion of today, the justice system. We have a lot of cases now. In Poland, for example, as you are looking on the streets, now we have electoral campaign, but in many cases, in many situations, if people are coming on the street holding some slogans which the government does not like, it's very likely that these people will be punished for violating of the COVID-19 legislation. And there are already fines which has been set on the members of the Committee for the Defense of Democracy and others, up to 30,000 zloty, and in an accelerated procedure. It is exactly what is met by our principle 4. But we have, and so this is a time where the judiciary may use the opportunity also for modernize itself, to use a technology which is coming. But of course, it is also a quite dangerous situation which can be abused. And then we have our principle 15, providing the guarantee, or trying to provide the guarantee that we have to return to the normality, to the regular functioning of the rule of law also, and to set a clear limits for using the coronavirus crisis to abuse the rule of law when the risk is gone. And this balance between the threat, between the emergency and using the opportunity is coming from we have experience in Eastern Europe in quite powerful way. It's not only the Polish case, it is also Hungary with its emergency situation, unlimited emergency situation. And now we are trying to start this with presentation of Leah Wortham, trying to showing us the perspective of the Eastern countries and why the Western countries should be careful, should be warned by the situation which is happening already in Central and Eastern Europe. Thank you, Leah, you have the floor.
Many thanks to European Law Institute for this invitation, and it's an honor to join this distinguished panel. This month, our moderator, Professor Zoll, and I completed a book chapter about Poland called Weaponizing Judicial Discipline, which followed on a 2019 law review article that we wrote. Those two works, close to 40,000 words and hundreds of footnotes, provide specifics on the comprehensive and complex assault on Polish judicial independence since the Law and Justice parties returned to power in 2015. Today, I will refer to the party by its Polish acronym PiS. PiS's governing philosophy is that their party's view of the national good and policy initiatives should not be blocked by judges citing law or the Constitution, or be constrained by normal parliamentary procedures involving hearing from the opposition or expert witnesses. Unlike in Hungary, though, PiS does not have a sufficient parliamentary majority to amend the Constitution. Wojciech Swiderski's excellent 2019 book, Poland's Constitutional Breakdown, outlines in detail PiS's multiple constitutional violations and amendment of the Constitution by unconstitutional statutes. The Polish Constitutional Tribunal had blocked some PiS actions when the party was in power from 2005 to 2007. So in 2015, PiS moved quickly to first disable and then take over the Constitutional Tribunal. PiS, though, met an amazingly united resistance from many of the about 10,000 judges who sit in Poland's common courts, the two judicial associations to which most judges belong, and from the Polish Supreme Court, which, with some help from the Court of Justice of the European Union, PiS was not able to completely pack and take over. The most obvious COVID-19 rule of law Polish story is the intersection with the presidential election, which was to be held May 10th and is now to take place on June 28th, at least the first round. One likely factor in PiS's choice not to invoke the Polish Constitution's provisions on state of emergency is what that would have done to the timing of the presidential election and a calculus of how that would affect the re-election chances of PiS-supported candidate Andrzej Duda. Today, though, I focused on what the Polish experience suggests for other countries about how weaknesses in a judicial discipline system can be weaponized to seek to bend judges to a ruling party's political will. Many countries' judicial discipline systems look like Poland's, so the lesson of how it has been exploited can offer a cautionary tale for other countries as well. The Polish Constitution generally codified strong guarantees of judicial independence negotiated in the 1987 Solidarity Roundtable, which spurred the end of communist rule. The Polish Constitution provides the architecture for a strong and independent National Judiciary Council. By switching election of the judicial members to the PiS-controlled lower house of parliament, 24 of the 25 seats in the National Judiciary Council are now directly linked to the ruling party. And judicial discipline is the legal silver bullet that can pierce the Constitution's guarantees to individual judges against removal, involuntary transfer, and salary reduction. As in many countries, the Polish statutory standards for a disciplinable offense are vague and broad. Moreover, the investigation and hearing process provides an excused judge many fewer procedural guarantees than those afforded to the criminal defendants who appear in their courts. PiS retained the statutory definition for disciplinary conduct as, quote, judicial misconduct, including an obvious and blatant insult to provisions of law and breach of the dignity of the office. Many judicial systems have similar languages. They assume that the decision makers applying that standard will be fellow judges who hold common values and will interpret such vague standards reasonably. To weaponize judicial discipline, PiS changed the decision makers. They moved the effective control of the investigation and charging process to Zbigniew Ziobro, the Minister of Justice, who also is the Prosecutor General, to whom PiS has given extraordinary control of criminal prosecutions and even prosecutors and even individual prosecutions. Ziobro is a member of parliament and the ambitious head of his own political party, which is joined with PiS in the United Right. PiS legislation has also shifted power to select who hears the cases in the first instance away from election by judicial assemblies to Ziobro, with appeals to a new chamber of the Supreme Court, which PiS created and then staffed with judges recommended by the National Judiciary Council that they control. That chamber also has jurisdiction to lift a judge's immunity from criminal prosecution. Ziobro was also given carte blanche for 6 months to replace court presidents and vice presidents who can punish and reward judges in a number of ways. The PiS government claims that they are abiding by the Court of Justice of the European Union's April 8th, 2020 interim measures decision, ordering a freeze on decisions by the Supreme Court's disciplinary chamber pending the CJEU Grand Chamber final decision. Nonetheless, with Polish courts effectively generally closed in the health emergency, the disciplinary chamber moved forward June 8th to hear their first case on waiver of judicial immunity, and other such proceedings are moving through the system. New disciplinary charges also are going forward against judges who are particularly visible in their criticism of PiS's disregard of rule of law, the Polish Constitution, and European treaty requirements. Amazingly, the government claims that the CJEU order extends only to disciplinary cases, not waiver of immunity cases, and the CJEU has asked for further response on compliance with their order on June 28th. That's an 8-minute blitz on a complex and terrifying story, and I will conclude there.
Thank you, Leah, very much for this presenting the situation to Poland, and now we are giving the floor to Professor Fowak-Kostum.
Thank you very much. Can you hear me? Yes?
Yeah, sure. Yeah, welcome. Yeah.
Great. Firstly, I want to congratulate the European Law Institute for these principles. and also for this webinar. I think that such initiatives importantly contribute to the development of a European vision of the judiciary's role in a democratic system. And Lea Warsom has just described the assault on Polish judicial independence and suggested that some countries may well face similar situations. Well, fortunately in France, there is no such assault. And I will use these few minutes to describe the way our justice system functioned during COVID. And I think that this functioning was well in line with Principle 5 of the ELI principles. In France, the judicial system not only maintained a minimum level of activity and postponed non-urgent decisions, but the Conseil d'État, operating as a Supreme Court for administrative matters, has tremendously increased its activity as regards urgent matters. It has constituted a task force of experienced judges who acted as the judge of urgent summary applications. And in very short times, sometimes 2 or 3 days, they have rendered more than 160 decisions on urgent claims related to fundamental rights during COVID. The judge scrutinized the legality of governmental measures, it searched for the right equilibrium, and applied the proportionality principle when different fundamental rights and objectives collided, typically the objective of preserving public health and freedom of movement. During the first phase of the crisis, from March to May, the Conseil d'État faced criticism in France for rejecting the vast majority of these claims and not being willing to challenge the government's measures. Such criticism, in my opinion, was partly based on a misunderstanding of the role of the judge in urgent summary proceedings. In such cases, the judge must verify whether a fundamental freedom has been manifestly and seriously infringed. And in doing so, he seeks to determine if the balance between liberties or fundamental rights is maintained, having regard to the context and to the situation at a given moment. So from March to May, when COVID was so virulent, the protection of health predominated. From May onwards, as the epidemic was declining, some governmental measures no longer appeared as appropriate and proportionate. Consequently, the Conseil d'État did not hesitate to order the government to lift some bans. And I will give you 3 examples. On May 18, the Conseil d'État ordered the lifting of the ban on assembling in places of worship and to substitute measures strictly proportionate to the health risk and appropriate at the beginning of easing the lockdown. On the same day, the Conseil d'État also ordered the government to immediately stop surveillance by drone of compliance with the health rules in force during the deconfinement period, which had started. It considered that the use of drones is processing of personal data and that the French law, recently reformed in accordance with the GDPR, was not respected. Consequently, it ordered the government to cease such surveillance as long as a decree had not been taken after the opinion of our National Data Protection Authority, or until the drones were equipped with a device making it impossible to identify the people filmed. Third example, on June 13th, last Saturday, after anti-racism marches took place in Paris, the Conseil d'État ordered the lifting of the ban on protests in public places which gather more than 10 persons. The judgment recalls that the freedom to protest is a fundamental right and decided that the ban on protest in public places is not justified by the health risk, except when physical distancing measures cannot be respected or the event is likely to bring together more than 5,000 people. The French Constitutional Court had already authorized meetings gathering more than 10 persons in private places. The Cour de Cassation, which is the French Supreme Court for private law matters, also contributed to the safeguarding of the rule of law. And it held notably that a provision of the decree of March 25, which established the framework of the state of health emergency, which stated that pre-trial detention can be prolonged, is susceptible of violating the European Convention on Human Rights, and that it is only compatible with the Convention provided that a judge examines promptly the necessity of the detention. To conclude, I shall make two comments, one on the role of the judiciary and one on return to normality. As Lord Thomas pointed out during the last webinar, I think that France has shown how courts can hold governments to account during such crisis. Thanks to open, reactive, and efficient judicial practices, the courts have managed to withstand the political stresses that arose because of pandemic. And this crisis has also shown how important it is for the judiciary to be prepared to communicate on its decisions and on its ways of reasoning, and not to be perceived as remote from the public. And I think that in Europe, we need more citizen education on the role of the judiciary. More generally, the rule of law can only flourish in a country whose inhabitants feel collectively responsible for the implementation of this concept. The second remark is as regard return to normality. This does not simply mean return to the past. There is a fear that governments use this opportunity to enforce measures that do not comply with the regulatory framework on privacy, particularly as regards contact tracing applications. In France, we had a large debate on the use of Stop COVID application, and it was scrutinized by the French regulatory authority, by the Conseil d'État, by the Constitutional Court. And perhaps this is typically the kind of topic that, as Principle 15.2 of the ELI principles suggests, could also be monitored by EU institutions.
Thank you very much, Benedikt, for this excellent presentation. Now we are going to Professor Stöckli. Professor Stöckli, you have the floor.
Dear colleagues, it is a great pleasure for me to talk briefly about constitutional law issues in connection with the COVID-19 crisis in Switzerland. And I would like to thank you for inviting me to this talk and for organizing this lovely event. Now, what happened in Switzerland during the Corona crisis? In Switzerland, the government took control of the pandemic. Parliament has been downgraded to a supporting actor for the time being. In mid-March, the Federal Council announced the extraordinary situation, ordered drastic measures to combat the pandemic, and implemented multi-billion aid packages to deal with the economic consequences of the pandemic. At the moment, rules are relaxed and the government is slowly going back to a sort of normality. On the other hand, the Federal Parliament had to cancel the third week of its spring session in March because the health protection of parliamentarians in the Parliament building could no longer be guaranteed. The media, they talked about democracy taking a break. Parliamentary law does not provide for the possibility of downsizing the parliament or holding electronic meetings in such situations. After all, a delegation from parliament had to approve the economic measures of the government in advance. The parliament then met in May in an exhibition hall outside the parliament building for an extraordinary Corona session. At that point, it should be mentioned that the federal parliament is a militia parliament in Switzerland that does not meet constantly, but only meets at regular intervals. Furthermore, I have to point out that legal protection is not possible in Switzerland against the Federal Council's emergency ordinances. The enforcement acts are based on the ordinances by federal and cantonal authorities, can, however, be subject to judicial control. As far as can be seen, there have been no judgments so far regarding official measures in the Corona crisis. Now I would like to briefly answer the question of how the measures of the Federal Council can be legally classified. For reasons of time, I cannot make a comprehensive legal assessment of the Federal Council's measures at this point. Nevertheless, I can say that the Swiss executive was fundamentally based on legal and constitutional responsibilities in the corona crisis. A distinction must be made between measures to combat the pandemic directly, these are the primary measures, and measures to deal with the consequences of the pandemic, the secondary measures. The primary measures are based on an article in the Swiss Epidemic Act. This is the Article 7. And it is an article that has existed for some time and allows extensive measures. However, the measures must be within the framework of the constitutional order and uphold the constitutional principles. Fundamental rights may only be restricted, of course, if there are overriding public interests. And the measures, they must always remain proportionate. The measures to deal with the consequences of the pandemic, secondary measures, are based on constitutional law. According to Article 185 of the Swiss Constitution, the Federal Council may, in direct application of this article, issue ordinances and rulings in order to counter existing or imminent threats of serious disruption of public order or internal or external security. In this context, a judgment of the Federal Supreme Court from 2011 is of considerable importance, in which economic stability has been recognized as an important public interest. Article 185 of the Swiss Constitution, therefore, also allows measures that serve this goal, although the scope is, of course, even wider. All measures to maintain public order are permitted. In one part of the constitutional doctrine in Switzerland, the opinion is held that the Federal Council left the constitutional order in the corona crisis. I cannot share this view for the reasons just mentioned. However, this is not to say that the Federal Council always acted proportionally in the corona crisis. These statements show that the legal order in Switzerland assigns the Federal Council primary responsibility for managing the crisis and endows it with far-reaching powers. This temporary increase in power by the government, which has a resource-rich administrative apparatus, has proven to be appropriate for maintaining the state's ability to act. The federal parliament is structurally less able to act quickly and effectively. This is particularly evident in a pandemic, as measures have to be constantly adapted to changing circumstances in order to remain targeted and proportionate. In order to prevent abuses, the executive emergency powers are already integrated in a corset of constitutional democratic safeguards that have been partially strengthened after the financial crisis. But of course, the corona crisis showed that this constitutional safety net has some deficits. The roles of the parliament and the courts need to be strengthened. I can make the following 3 suggestions for improvement, and we can also say these are in a way constitutional learnings from the crisis. First, the role of the Federal Assembly in extraordinary situations and the democratic legitimacy of the measures could be strengthened through the prior and accompanying involvement of the entire parliament or a parliamentary delegation. For example, the Federal Council, the executive, could be obliged to periodically submit to Parliament the question of whether the conditions for emergency action are still met. Secondly, the legal basis should be created so that Parliament can also meet virtually in exceptional situations. This could enable Parliament to remain more effective in such situations. Parliamentary sessions would no longer have to be cancelled. And the third point, the last point, and probably also very important for this webinar, the legal protection gaps should be closed in relation to the application of emergency law. In particular, consideration should be given to creating the possibility that an appeal can be made to the Federal Supreme Court directly against emergency acts of the Federal Council. As already mentioned, this is not possible today. For this reason, the Federal Council's corona measures have so far not been subject to judicial review. I thank you very much for your attention.
Yeah, thank you very much, Professor Stöckli, for this very interesting speech on Switzerland. And then we are coming to Dr. Ziółkowski from Koźmiński University.
Thank you very much, Mr. Chairman. Thank you for an invitation. When we refer to COVID, Poland may be easily misleading from the comparative perspective. The official government narrative is that Poland is at the forefront in that battle. The government opted not to use constitutional power to declare a state of emergency. The parliament was not formally deprived of its powers. It regularly proceeded on partially online sessions. The judiciary was attacked and partially captured by the executive before the pandemic started. So there was no need for the government to use the COVID as a camouflage for unconstitutional reforms of the judiciary. Indeed, the court's proceedings were suspended at the beginning of the pandemic, and it was a very sneaky move. Individuals had no remedies against confinement or other COVID-related sanctions. The suspension of the provoked more detailed questions concerning delays and deadlines. However, after 2 months, the court started to continue their job, but this job is extremely difficult now since the online sessions have not entered into force. In the meanwhile, the rule of law crisis in Poland jumped into the new phase. The devil is chaos. This short intervention is to sketch how the COVID boosted constitutional crisis in Poland. Let me give you 3 arguments. To discuss it, I will follow and refer to the European Law Institute principles, namely number 1, 3, and 4. Poland should have had the presidential elections in having regard to the fact that the constitution provides rather a rigid system of election dates. There was only one right to change the voting day and to postpone the elections due to the outbreak of COVID. That option was to use the emergency powers provided by the Constitution. It would allow to organize elections to the north. That option was in the government's hands. However, the government refused to do it. So, the government insisted on voting in May when compulsory quarantine and other restrictions directly limited constitutional right to vote and right to stand as a candidate on equal conditions were enforced. All in all, the government failed to organize voting in May. To be precise, the elections were not formally postponed, invalid, or voided. The ballot did not happen. The day after the ghost voting, we woke up in a situation of permanent unconstitutionality. The political majority intensified that unconstitutionality and adopted in June a very particular statute on the presidential elections in time of pandemic. That statute gave the Speaker of the Sejm power to choose a new date for the elections, whereas the Constitution clearly excludes such a discretion. That statute also introduced illegal fiction and transformed candidates in the old elections into the candidates in the new elections. The statute allowed to notify a new candidate, but she was given a few days only for collecting 100,000 signatures of supporters. The statute de facto reduced the presidential campaign to the minimum for all candidates, except, of course, the current president in office. The statute introduced also the postal voting in case of COVID spreading, but the statute left only 14 days for the authorities to prepare, distribute, receive, and check all ballot papers. If the authorities fail to count all votes in one electoral district, the voting in that district will be considered as non-existent. Last but not least, the authorities were given the power to decide whether the elections in a foreign electoral district are possible or not. Again, the election rules were modified in less than a month before the voting. The second argument concerns the fiction of the parliamentary debate, the difficulties with the parliamentary scrutiny. Between March and June, the Parliament adopted 8 statutes which were aimed to fight with COVID. It introduced new legal institutions and temporary solutions in almost all branches of law. The single statute amended up to 53 other statutes. Swift parliamentary sessions proceeded all changes without time for a substantive debate. The role of expert was reduced to the minimum. 2 of the statutes were adopted with a serious violation of the same standing orders. The average time between the submission of the bill and the adoption of the statute was 4 days. The most demanding statutes in terms of legal, social, and economic expertise were adopted in 3 days only. MPs were left a limited time to read, understand, and discuss scope of changes. As a result, the Parliament had introduced internally contradicted provision that became amended in next 2 months. Moreover, the government mixed the legislation responding to the COVID with other legal changes, which were convenient for the political majority. The important substantive changes of criminal law were hidden in a bush of the new provisions. The Jagiellonian University experts observed that the changes were obviously irrelevant for the fighting with COVID. The government introduced a new type of the offences and increased some of the criminal penalties. Another changes which had been hidden in the COVID legislation concerned the electoral law. My third argument concerns legality and proportionality of human rights limitation. The first COVID statute allowed to limit freedom of movement, freedom of assembly, access to culture, economic freedoms, right to education, and many other constitutional rights. All the limitations were introduced when the number of the new infection were relatively low in March and April. When the number rapidly rose in June, the government revoked most of the limitations. Last but not least, some of the limitations had no legal basis. Thank you so much.
Thank you very much, Dr. Ziółkowski. And now we are coming to our last speaker before the discussion. We have an honor to have you, Lord Mans.
Thank you very much indeed. Thank you for inviting me to take part. I've read the principles and they are admirable, and they contemplate as far as possible the continuation of the ordinary role of lawmakers and of the justice system in times of crisis, and that is right. In times of war, the law should not be silent. I was interested to hear the position in Switzerland. In fact, in the UK, Parliament is sitting remotely and voting remotely, and yesterday we succeeded, sitting in this room, in voting down a clause 2 of a bill, the Private International Law Implementation of Agreements Bill, on the grounds that it gave excessive powers to the executive to introduce new domestic law by delegated legislation. And that is, of course, the sort of thing that governments tend to do when they want to, when they overreact in crises, and the principles seek to guard against that. Our justice system is operating. In fact, my wife, who's a Supreme Court Justice, is sitting remotely downstairs today. So that I'm afraid we can't claim in the UK anything like as dramatic decisions as Benedict Faure-Casson has told us about, which I gather Lord Thomas, my former colleague, has commended. They do sound commendable. In the UK, the only litigation I can point to is by British Airways complaining about the restrictions on the number of air passengers on aircraft. There's been very little judicial response to some very stringent measures by the government. The general population has been extremely accepting and has in general adhered to these restrictions, now relaxed somewhat. There has been recently more signs of disobedience, but not leading to litigation. The threats we're talking about, political interference with independence and of course over-interference in times of crisis, are as old as the hills. These are simply situations in which they come very much to the fore. And I thought it would be interesting just to note the remarkable development of European Union jurisprudence in the field, because until quite a short time ago, the obligation of mutual trust between European legal systems and institutions used to, in the eyes of the European Court, override any consideration of actual defects or unfairness in other EU systems. And it led to a pretty mild scrutiny of the exercise by the European institutions of their powers. I'm not sure that that has hugely changed, but I'm not speaking about that primarily. I'm really speaking about cases like Aranyosa and Calderaru and the other PPU case, where the court began to become very interested in the practical impact of the operation of systems of justice, whether conditions of detention were inhuman or degrading, whether there was a real risk of breach of the fundamental right to a fair trial if you ordered someone to be extradited to another EU state. And it seems to me those were remarkable and very welcome developments to protect fundamental rights, to protect the rule of law. Now, traditionally, the UK was rather reluctant to see the EU involved in the operation of national legal systems, but I think those were a good example addressing fundamental problems where the EU stepped forward. And the Polish cases, of course, continue the same theme very much, protecting right of access to justice. The only small note of disappointment I record, but the Court of Justice really had no option, was that its dismissal of Poland's argument that the political role in the renewal of judges under the new Polish legislation was, Poland argued, no difference in substance for the procedure for renewal of judicial appointments to the Court of Justice. Well, I'm afraid there is some force in that, but the Court of Justice, all it could give as an answer was that the European procedure was laid down by the treaties, and then it referred nicely to the Article 255 panel. Maybe the European international appointments to supranational courts might be slightly, in an ideal world, different. The position, of course, is not always easy when one comes to the actions of constitutional or final courts like the Court of Justice. In the United Kingdom, that's recognized by the fact that we don't actually have a written constitution, and we place on a par with the rule of law the principle of parliamentary supremacy. Of course, potentially they're inconsistent, but in practice, mutual respect and tradition avoid clashes. One of the possible difficulties, which certainly for some was presented by the European Union, was the effective existence of a European constitutional court, the Court of Justice, whose supremacy was absolute, replacing, in the eyes of some, parliamentary supremacy by a rule of judges. Now, Personally, I think that was a fear that was, and a concern that was exaggerated, and that the way to address it could have been to remain within. And of course, the UK Supreme Court would have found fellow thinkers. We've just had a remarkable decision from the German Constitutional Court, which actually holds the Court of Justice to account on the grounds that it failed manifestly to pay proper attention to the principle of proportionality when blessing the decisions of the European Central Bank. Now, of course, there's another side to that judgment. Fears have been expressed that it could undermine the Polish jurisprudence, which I've just commended. But they're in different spheres. I think the Polish jurisprudence is in the area of fundamental rights, and the German Constitutional Court was dealing with different matters. It was dealing with the competences and exercise of powers under the treaties, which I think would suffer, do benefit from close scrutiny and a certain element of control, which may perhaps result from the encouragement of the German Constitutional Court to remain within what it perceives, at any rate, as the boundaries. There shouldn't perhaps be too strident an assertion that there is only one ring to rule them all, because after all, the European flag portrays a circle of stars, not a sun surrounded by stars.
Thank you, Lord Mans, very much for this speech. And now we are opening the floor for discussion, so I will try to coordinate it. So you are all welcome to put the questions on our questions and answers form or on chat. We'll try to coordinate it. But before this question will come to us, I think we have one first issue, which was probably the starting point of consideration. Poland in March and in April was kind of a dream for a dictatorship in certain sense. So the borders have been closed, the courts were closed, the parliament session was postponed or organized differently with online, but with quite limited right to participate in a discussion. So it was exactly something which you can imagine that a kind of dictator who is not really, who does not like the discussion in parliament, does not like courts, and does not like other countries or international relationships, he could be really happy in this situation. And of course, this is the quite interesting question for all of us, whether this what has happened could somehow be perpetuated after the COVID-19 crisis. So do you think that this COVID-19 crisis would remain only a small story which does not infringe the rule of law in all our countries, and we will, from this perspective, we have just a short moment in the history, or it will be something which will change Europe and the operation of the law in more fundamental way, and giving more power to the executive. It is really a threat, and somehow limiting also the operation of courts, with tension between the interim measures or different measures, extraordinary measures, administrative measures, and the judicial power, which was somehow postponed. What will remain out of this after the crisis? So we can start now. Yes, so who would like from you to answer this question? We can, maybe Leah, we can start with Leah. You have been unmuted. You are muted.
Yeah, I am mute. No, I'm unmuted. I think you can hear me right. I think, because I primarily am looking at it from the perspective of Poland, there was already so much damage, and there's already such an overwhelming task in terms of thinking how to dig things out. And of course, with judges, I mean, I was struck when Benedict had talked about the importance of citizen education, because one of the things over time that the Polish judges had finally done, because they had been very insular, really, but they really learned that lesson. And there were, 30,000 people demonstrating in January. And, Polish, who knew that judicial independence really could, and there really a lot had been accomplished. And the COVID-19 provided such a wonderful opportunity for the government to try to walk back what had become pretty successful. And so I think, of course, there's a lot of awareness, and so much now in Poland really depends on, the election. And ultimately, all of these questions, I think, in the end, do have to get solved by the voters. I mean, so you really ultimately have to have people who believe. Of course, the Court of Justice European Union has been incredibly important. And one of the things Frederick and I have been looking at is another article about trying to weigh all the different actors that kept things from being so far as disastrous as they could have been, and the CJEU has been critical. But I think it's hard for me to answer that question, except seeing specifically how it's already made a very difficult situation in Poland even more difficult.
Benedict?
Thank you. Well, it's difficult to anticipate, but I really think that the focus now should not only be on ensuring quick post-pandemic recovery, and that member states and also EU institutions are constantly facing new challenges for the application of the rule of law. And I believe that we will have to be very vigilant, because indeed, as Frederick said, there are new risks of situations that we would not have anticipated before the COVID crisis. And also we have to make sure that temporary measures will be put to an end. And this also is a big issue, and it has been tackled also by the principals. And that's also important to remain very aware that the rule of law may be affected in different manners that we had not anticipated before the crisis.
Professor Stöckli?
Thank you very much. So for me, it's difficult to speak about Poland, but of course there are a lot of differences between the democracy in Poland and in Switzerland. I think we have a quite strong democracy in Switzerland, and therefore I'm also not afraid that we can go back in a situation where there is where the principle of democracy, rule of law are still existing. I'm not afraid of that. I think the executive took a lot of responsibility in the crisis, and the executive had the power, had the legal basis. According to me, the Federal Council was within the Constitution. Of course, we can talk about several measures, but therefore, in this point, we have also to mention that it was also very difficult for the government to, under this uncertainty, to make always the right decisions. This we have also to see. When we are looking at these measures, we have also to see what we are saying when we have a look ex ante and ex post. This is an important point I have to mention. But of course, also in Switzerland, we have to do a lot of things. I mentioned 3 important points. There are more things. I think the most important thing is that the judiciary has to become a more important role in situations like that, in extraordinary situations. But I think executive is giving back the power. We have also several safeguards. So according to the Constitution, the government has to prepare a law so that all these measures then will become parliamentary law. So we have all these kind of safeguards already in the system. But I see several points, of course. But I think it was I think government acted in a very good manner. I think it was a good, and also the system is quite good, but with several points we have to now to adjust.
Thank you very much for this optimistic perspective. For all attendees here, please for questioning, for making questions, could you use the chat or questions and answers form? Some people have raised hands, but I don't see the questions. So if you can write the questions, just I will collect them and ask our panelists. If you allow. Okay, Dr. Ziółkowski.
Thank you. I'm afraid that your forecast is absolutely justified when it comes to Poland. Firstly, COVID pushed public attention on this matters than independence of the judiciary. Secondly, COVID legislation limited human rights without time, with no time limit, with no time limits, particular time limits. So generally, even after return to normality, part of the limitation will stay. And the third argument is that COVID legislation provided a clear shift in favor of the government, because COVID legislation provided vast authorizations for the ministers to adopt resolutions in order to limit human rights. And the wording of that authorizations were sometimes so nebulous, so blanket, that a lot of experts in constitutional law recognized them as an example of unconstitutional delegation of legislative powers to the government. And I'm afraid that part of these authorizations, of these statutes, will stay with us. So generally, I'm afraid that COVID created a clear shift in favor of the government.
Lord Mans?
Yes, that's really a development of, I think, a continuing modern problem which existed before COVID. Governments like to rule by what we call delegated legislation, and they include as often as possible in primary legislation what we call Henry VIII clauses, which allow them later to introduce any sort of subordinate legislation they like. And it's a perennial risk against which Parliament has to a considerable extent fought. Just to go back to the bill yesterday, there were two committee reports, the Constitution Committee and another committee on delegated powers, both condemned clause 2 of the bill, which was a completely blanket provision with no sunset clause, no limit in time. And nonetheless, the government pressed ahead and wanted to pass the bill. The positive side is that it was voted down, if I remember rightly, by 320 to 233 votes. And if you ask for a lesson from the current crisis, it is to be found in that number of members attending. That is a large majority of the House of Lords, and it's an extraordinary number, I think. And it's only possible because we were sitting remotely and voting remotely. There were about 15 people in the chamber, everybody else was at home. And I think that if some good comes out of the present crisis, it may be much more use of remote technology for both parliamentary and judicial hearings, because I think it does work. And although lawyers will complain, oh no, we want to see the judge's eyes, be there in presence, I am aware that in many continental countries, there aren't oral hearings as there are in the UK. Much more of the work is done remotely anyway. And I think this is a positive which might come out of this crisis. But the negative is we've got to avoid this tendency by government to govern by its own delegated legislation.
Thank you very much. We have several questions, but two at least we can manage yet. Firstly, from Mr. Iglesias, the question about the rule of law and the role of the higher courts in our countries in this situation, and then of course whether there is some specific pressure of the executive branch now on the courts and on the higher courts, which is somehow linked to the COVID-19 crisis. So can we find out some kind of specific situation of the higher courts? We have in Poland, of course, a very particular situation, which was related to the COVID-19 in the sense that it was some extraordinary assembly of judges called to elect the new president of the court, and there are doubts about the legitimacy of it. So it is somehow an effect of the COVID-19. But do we have other reflection about now the special role of the higher courts as a guardians for rule of law, but also especially affected by the government trying to monopolize the power? Can we find something like this in our situations? Who wanted to take the floor? Benedict, you are. Yeah.
I was very interested in Andreas' third suggestion. When Andreas, you said that it's important that appeal can be made directly to the Supreme Court, and that currently it's impossible, and this is the reason why there was no judicial review for corona measures. So to answer Frederick's question, I think that there is a distinction to be drawn between countries such as France, where a Supreme Court can be directly seized of a question as a first instance judge because of this urgent procedure that existed already before COVID, and that has been used so frequently during COVID crisis, and other countries where it is not possible, and therefore judicial review during the 3 or 4 months that we have just lived was not possible for this reason. At least I think that this is what I understood from the Swiss situation. And if we can draw one lesson from this, is that perhaps it's also a procedural question, and allow more appeals to be made directly in urgent situations, so that consequently you have a better review of what the government is doing.
Thank you very much for this. And now we have the last question, which we can answer. You can also formulate all other questions via email or other devices to the Secretariat. We will distribute them further and try to find the answer to this. But the last question is about the role of the lawyers in this COVID-19 situation in Poland in particular. It was the question of Mrs. Kynast. So what is the role of the lawyers now in observing the rule of law, or in this particular, the question is related to Poland, but I think we can also generalize it somehow. Leah, the role of lawyers.
Just the first thing I would say is the last 3.5 years have made such a difference, in my opinion, about how the legal professions have adopted more of a common ethos, because as an American, I was sort of shocked at one point to say, lawyers and judges don't think they're in the same profession. And people looked at me in Poland like, well, of course not. But, in the United States, judges are lawyers first. And we have a very strong common ethos. And I think one of the things that has been very positive, which I see carrying forward, I think, in COVID-19, was judges reaching out, legal professions reaching back, and having a common understanding about judicial independence, rule of law, again, back to Benedict's original point of that being so critical. And there's been so much activism. I mean, the Polish ombudsman has been heroic, and there have been leaders in the judicial associations who've been heroic, the current president of the Senate. And so I think before COVID-19, you already saw lawyers acting very differently in Poland than they acted 5 years ago. I mean, and there's just been such relentless review of what the government's doing all the time. And Poland's blessed by a very vibrant, albeit beleaguered, free press. But there's been incredible civic activity, which I think was already in place. And I think it just continued as best as could in COVID-19. But if we had been Poland 5 years ago and COVID-19 had happened, I think it would have been a very different story about some of the threats. But Frederick would know better than I, so, and also, yeah.
Thank you very much. We'll this is a never-ending discussion. We have to go to come to our end of this very interesting discussion. We have to find also language to discuss all these complex issues. Maybe we haven't answered our fundamental question whether this what has happened in the Central Europe will impact in certain sense, or is a warning for the Western Europe. I think it is a story on some necessity of the stress test, that it is necessary to look on our institutions in all of the world and looking whether they are sufficiently secured in the kind of situation where the populists are taken over and they may endanger somehow the autonomy of the independent courts, judges, or other institutions which must remain independent from the executive branch. Thank you very much for being with us in this session. I think it was interesting. It had this complexity. I hope you have enjoyed it and you learned. Thank you for all questions. And this discussion will continue. It must continue because it is so important for our future and for our sake. Thank you very much.
Thank you
For being with us. Thank you.
Thank you.
Thank you.
Thank you. Thank you for.